Hello and welcome to the Indiana Lawyer Podcast, your source for news and Hoosier law, brought to you by Taft. I'm Alexa Shrake, Indiana Lawyer reporter, and your host this week. I'm here in our Monument Circle studio with Garrett Hutchinson, an associate at Taft. Garrett focuses his practice on intellectual property and trademark and copyright prosecution. So to start, Garrett, we have Taylor Swift coming to Indianapolis in just a few weeks. How has the re-recording of her old albums opened questions on intellectual property and contract law?
Well, first off, Alexa, thanks so much for having me on today. And that is a great question. I think other than adding Taylor's version to the modern lexicon of meme words out there, I think the answer there is actually pretty huge. What Taylor Swift did was kind of unprecedented in the music industry. She had recorded 6 albums on with her label Big Machine between the years of 2005 and 2018. And as we all know, later left Big Machine. They sold her catalog, and then she went and re-recorded a lot of her tracks and published her own Taylor's version. So the reason she was able to do that is because, as many of our listeners know, is that there are 2 different kinds of copyrights in a song. Unlike other kinds of works, there's the rights in the song itself, the composition, which are referred to as the publishing rights, and then there are the what are known as the masters or mechanical rights, and those are the rights in a specific recording. And up until Taylor Swift's kind of move away from Big Machine, the norm was for record companies to let the composers keep the publishing rights, and they would keep the mechanical master rights. Usually, there would be a lockup period to prevent people from doing what Taylor did, but that lockup period would usually be pretty short, in the range of 2 to 3 years, so that artists could still record live albums, things like that, if they ever switched labels. So really, what she did didn't change anything legally. It just changed kind of the mechanics of the negotiations with record labels. Whereas before, they were willing to kind of bend on those lockup periods and didn't really see that as a real threat to what they were doing. Now that's something that they look at a lot more closely. I've even read about some labels that insist on 20 to 30-year lockup periods. A savvy entertainment lawyer will push back on that for the artist, of course, but really their goal is to kind of put those publishing rights locked until the economic value of the song goes away, so that if they do re-record it, their voice is gone by then, or the interest in the song is past, and it doesn't really harm the record label. The other kind of big thing to think about is just the impact that this has on large-scale IP purchases and due diligence and those kinds of transactions. We've been seeing, I think, a lot more concentration of larger companies and equity firms buying up large copyright portfolios for millions, sometimes billions of dollars. This kind of adds another wrinkle for the lawyers to look into and make sure that they're very clear on those publishing rights and those what those lockup periods look like, because that is something that used to not really be a real possibility that people considered as much. And it also has made a lot of the record companies a little more thoughtful about how they address future licensing in their contracts, because now that Taylor Swift, having the publishing rights, has her own master versions, she has a 50-50 say in most of her record labels' licensing deals if they want to do them, so she can kind of shut them out and force people to go to her masters, which is something that I think record labels are going to want to try to avoid in the future.
That's all very interesting, how she's changed, how that all works. So, also in the music industry, Miley Cyrus has been accused of copying Bruno Mars' song in a new lawsuit. This isn't the first time an artist has been accused of copying another's work. So how do these cases typically get handled? What have you seen?
Absolutely. So these cases are interesting because it's rarely as simple as somebody straight up copying someone's song. The cases where, illegal downloading, something where it's an exact just reproduction, those can be, if not easier. The tougher cases come in cases like this where there are similarities, and it kind of comes down to how similar is too similar, right? In a technical sense, there are 2 main elements to copyright infringement. One is access and one is copying. The access element is usually not that hard to prove, and it can be presumed if a song is big enough. So something like a Bruno Mars hit, you can pretty much say that the access element there is going to be met. copying is harder because there's rarely direct evidence that somebody sat down and copied a song. I'm sure those cases exist, but it's pretty rare that someone there's a video or some recording of someone looking at the music and copying it down. It's just not really how that kind of process happens. So judges have developed this sort of quasi-test to allow us to approximate that. If something is strikingly similar, if it's so similar it's kind of unbelievable that this isn't a copy, then they'll let copying just be presumed from that. If it's not to that striking similarity, they have to show direct access plus probative similarity. And probative similarity is more like substantially similar. That doesn't necessarily have to be of protectable elements, but it has to be just sort of in toto enough to where it makes it more likely than not, I would say, that this was copied. Some of those probably will be protectable elements, but a kind of famous law school example is maps are copyrightable, and it used to be that cartographers would put a mistake in their maps so that they could prove someone had copied their maps because no one else would make that same mistake. Those kinds of things can show that copying occurred. I will say, though, that there's been some in the past 10 years or so, a little bit of a shakeups in that area. There was a case with the song Blurred Lines with Robin Thicke, was sued by Marvin Gaye, and that in that case, the Ninth Circuit found that the similarities element was satisfied just because the Robin Thicke song had the same feel as the Marvin Gaye song, which was pretty unprecedented. There haven't been a lot of cases that have really since then that have really gone down that line and held in a similar manner, but that has really changed the risk analysis on the front end for a lot of artists because it really ups the potential to walk backwards into liability without actually having intentionally copied something.
Well, that's interesting. What are some of the misconceptions that you see people have in your practice area?
There are a lot in intellectual property. I think the most common one is just not to use Blurred Lines so close to talking about that song, but the most common one is probably people blurring the lines between copyright, right of publicity, trademark, and not really understanding where one ends and the other begins. I'd say for an audience like this, though, the ones that I see lawyers miss the most are probably work made for hire, thinking that there are really limited situations where if someone working for you makes a work that you'll own it. And I've seen a lot of attorneys think that that's a lot broader than it really is. The general rule is if somebody's an employee and they create a work within the scope of their employment, the company will own it. But if it's an independent contractor, it's very narrow when the company will own that work. And I've seen so many times where it's actually not something that can be overcome in a contract. You can have the other side sign that you're the author and this is a work made for hire. That may transfer ownership, but it won't make the company the author, which has legal implications. And that's led to some situations where I've seen a company pays a marketing firm to develop a trademark. They have trademark rights in that logo, but they don't actually own the copyright in it because they didn't get the right paperwork on the front end, and then kind of find themselves in a sticky situation.
So how do you see copyright and trademark changing in the future?
I think that there are a lot of answers to that question, and they mainly come down to two things. The internet kind of changing in the way it has in the past few years, and the other being artificial intelligence. To start with the internet, I think that we're seeing a much more risk-adverse landscape as far as what web hosts are willing to allow on their websites. Particularly recently, there's been a rise in what are called copyright trolls, quote unquote, and those are companies that have technically enforceable copyrights, but either it's not economically viable to sue in most cases, or there's some other issue. Maybe they just buy just the right to sue and then kind of use that to just attack online users and try to get $1,000, $5,000 settlements. I think in recent years we've seen that grow exponentially just because the tools that they're able to use online to find when a photo is posted on Twitter or when a company puts a stock image on their website have become a lot more sophisticated, and they can kind of catch anything out there within seconds now. On the trademark side, I think that unlike copyright law, copyright at the inception of the internet, we passed the Digital Millennium Copyright Act, and that kind of gave us a system for working out copyright infringement online. In trademark, there's just case law, and it's kind of set a much lower standard for the hosts of websites for what they have to do than is applicable on the copyright side. And really, I think practically what that's led to is a much more registration-focused system, because a lot of that enforcement of online infringements has fallen to private companies like Amazon. And with that, because they're kind of held to a lower standard for when they're going to be held liable for infringements on their platform, they generally require registrations before they'll take anything down, even though trademarks are based on use, not on registration. So I think that's led us to kind of more of a registration-based system. I think the theme among both of those things on the internet side are that it's really important to invest in risk management on the front end, because it's very easy to walk backward into infringement these days. And on the other side of that coin, invest in protecting your IP on the front end, because it's paradoxically also getting harder to enforce that IP with some kind of the explosion of ways that it can be infringed.
You mentioned AI, which is definitely on people's minds these days. How has that affected your work? Do you see more people, registering, to applying for the copyright and trademark to protect their work?
So that's a great question, and it does open up a whole host of issues. Most of these are still kind of being figured out as we all go, and mainly when I say that, I mean by courts. One big issue that's arisen with AI and copyright particularly is that copyright requires human authorship. So an AI actually can't create a protectable work. And a lot of companies don't know that. So that may lead to accidentally creating something that you really want to protect. It's a core asset for your company, and then you can't protect it. That comes up a lot with software code, because right now AI is being used heavily to create code. Another issue that pops up a lot from that is what's being fed into the AI and whether that's an infringement. That's still very unsettled, because the AI learns from putting in data, and a lot of that data is copyrighted. So the questions arise whether what that AI puts out is then a work that's derivative of the data it took in, whether it can even be an infringement because it's not by a human author. And there's also some related issues. There was one case that was kind of high profile where some software engineers wanted AI to help them write code, and they accidentally broke trade secret protection because that code was a trade secret. They put it into the AI, which then learned from it and spat out similar code to somebody else, and they accidentally lost their company a whole bunch of money. The other main thing I'm seeing come up a lot is just with the ability to kind of impersonate or approximate personalities and humans using AI. I think that we're starting to see, and will continue to see in coming years, the right of publicity become more important, which is a person's right, state-based in most states, in their name, image, and likeness. Tennessee recently passed a new right of publicity law specifically to cast a broader net and catch more artificial intelligence-based infringements of ROP. But beyond the infringement context, there's also a lot of opportunity for companies and for personalities and ways to monetize that. I was actually early in my career. It wasn't actually technically artificial intelligence, but around 2019, 2020, before the sort of open AI revolution that's happened recently, I was lucky to be a part of some of the first projects licensing the likeness rights for digital humans to have personalities that were no longer even alive, star in movies or TV shows or ads, things like that. I think that as that becomes more and more prevalent, we're going to be seeing people's name and likeness be considered as an intellectual property right, which it has been for years, but more up in the echelon of trademark, copyright, patent, one of those that we all kind of think of as in that core bucket of IP rights.
So yeah, you mentioned earlier CLE that you have coming up. You want to talk a little bit about that?
Thanks for bringing that up. I did want to mention while here, since we were discussing Taylor Swift's impact on copyright law, I am actually a member of the Indie Bar Foundation in Indianapolis, and am on the Sports and Entertainment Executive Committee. We're having a really exciting CLE later in the year. On October 29th from 4 to 6:30 p.m. It's called Lyrics to Legalities, Navigating Today's Music Industry. And it will give us give people who are interested a little bit of a deeper dive into some of these issues. We actually will have someone who has worked on litigation matters for Taylor Swift speaking there, as well as counsel for Gainsbridge, who will talk about some of the other non-IP issues that can come along with an event kind of this magnitude. Anyone who's interested in learning more or attending can go to www.indiebar.org/music. Again, that's www.indiebar.org/music. And there's a sign-up link there for both in-person and virtual options.
Oh, excellent. That sounds really fun, honestly.
I think it'll be a good time. There'll be food and drink and a lot of good information to be had.
Excellent. Well, I think that'll wrap us up then, unless you have anything else.
I don't. Thank you.
Awesome.
And I appreciate you having me on today.
Great. All right. So that'll do for this week's interview. Garrett, thank you again for joining me today. Stick around after our sponsor break to hear this week's headlines.
Taft, today's modern law firm. At Taft, we cultivate a highly respectful, transparent workplace that fosters creativity, teamwork, inclusion, and diversity. We couple our culture with a client-first approach, rewarding lawyers who understand their clients' goals and work to deliver success. Taft, the modern law firm. To learn more, visit taftlaw.com.
Welcome back. Managing editor Daniel Carson and reporter Maura Johnson and I are here to give you the rundown on the latest legal news. So let's get started. Today is Wednesday, October 16th, 2024, and these are your headlines. To start, Maura, you have news on a furniture retailer's lawsuit. What can you tell us?
A former employee with Indianapolis-based furniture retailer Kittle's Home Furnishings filed a lawsuit against the company after it allegedly failed to immediately notify employees of a data breach involving their personal information. The lawsuit, filed on behalf of lead plaintiff Christopher Ballard in Marion Superior Court, claims that between February 7th and 17th, 2023, Kittle's lost control of its current and former employees' highly sensitive personal information during a data breach. Ballard is seeking class action status for the suit on behalf of those whose personal identifying information was compromised by the incident. According to the suit, nearly 4,500 individuals were subject to the breach. On September 16, 2024, more than a year and a half after the breach, the company mailed written notices informing individuals that they discovered the, quote, security incident on or around February 17, 2023. The company's letter explained that an unauthorized party might have obtained personal information, including social security numbers, driver's license or state ID numbers, banking information, and health insurance information. The letter was also posted to the company's website. As a result of the breach, Kittle's offered potential victims, quote, proactive fraud assistance and access to a year of free credit monitoring. Ballard is suing the company for negligence, breach of an implied contract, unjust enrichment, and bailment on behalf of all affected current and previous employees. He is seeking a jury trial and asking for equitable and injunctive relief. Kittle's was founded in 1932 and has 7 stores in Indianapolis, Greenwood, Bloomington, Lafayette, and Fort Wayne. A representative for the company did not immediately respond to Indiana lawyers' request for comment.
Thanks, Maura. In a fiery debate between the candidates for Indiana Attorney General, Republican incumbent Todd Rokita and Democrat Destiny Wells spent a lot of time sparring over the role of the office in hot-button issues such as abortion and immigration. Moderator and TV news anchor Dan Speller opened the debate, which aired Sunday on Fox 59 and CBS 4, by asking the candidates to describe what they think the role of the office should be. Rokita said he sees the job as protecting jobs and the economy from, quote, bad Washington, D.C. ideas like the Green New Deal and better controlling the open southern border to prevent the deadly spread of fentanyl. Rokita said his role as protector has resulted in his office attaining a 94% success rate in keeping criminals behind bars and the collection of $1 billion from corporate wrongdoers over 3 years. Wells framed the office's role more as one of public service, seeing it as being a continuation of her service in the Indiana Army National Guard, where she is a lieutenant colonel, and as a former deputy attorney general under the former state attorney general Curtis Hill. Later, she accused Rokita of overstepping the office's authority on the issue of abortion by scaring doctors away from the state, and on immigration issue by taking a trip to the U.S.-Mexico border at taxpayer expense. Speller specifically asked Rokita about the disciplinary action imposed against him by the Indiana Supreme Court due to public remarks he made in 2022 about OBGYN Caitlin Bernard, who performed a medical abortion on a 10-year-old girl from Ohio. Rokita was reprimanded by the court, which found that Rokita's comments had, quote, no substantial purpose other than to embarrass or burden Bernard. Speller noted that it is still possible that Rokita's law license could be in jeopardy due to the subsequent complaints filed against him with the court, and he asked Rokita what would happen if his law license was suspended and he couldn't continue as Attorney General. He said he doesn't think his license can be suspended. Rokita said that a separate investigation by the Indiana State Medical Licensing Board agreed with him by reprimanding Bernard for a patient privacy violation. However, it rejected other issues raised by Rokita, with the board president calling Bernard a, quote, good doctor. Speller then asked if Rokita would change anything about how he handled the situation. Rokita said he wouldn't change anything. The debate ended by asking both candidates to say something nice about each other. Rokita called Wells a fighter. Wells said Rokita, quote, stays in it for the long haul. Back to Maura for news on a request to set an execution date for an Indiana prisoner.
Counsel for Benjamin Ritchie, a man convicted in 2002 of murdering Beech Grove police officer William Toney, have until November 1st to file a clemency request in response to the state's motion to set an execution date. Indiana Supreme Court Chief Justice Loretta Rush wrote in an October 3rd order. In a September 27th motion, the state argued Ritchie has, quote, no further grounds available to review his convictions or sentence, and that there's no active stay preventing his execution. Ritchie's new counsel has not represented him before and asked for time to complete their review of Ritchie's case file to determine his next steps. Amy Carozos, lead public defender for the state, told the Indiana Lawyer on October 7th that Ritchie's counsel will file a response and are assessing the best route to take. Appellate Rule 34 permits a party to file a response to a motion within 15 days after the motion is served. Appellate Rule 35 permits extensions of time for briefing deadlines. The Indiana Supreme Court granted Ritchie 30 days to file a response to the state's verified motion to set execution date. He must submit the response by November 1st. The state then has until November 18th to respond to Ritchie, and Ritchie will have until December 2nd to file a response. The Supreme Court will then take the state's request under advisement at the conclusion of the briefing. Ritchie was convicted of shooting and killing William Toney during a pursuit after Ritchie and two others stole a van from a gas station on September 29, 2000. Ritchie was 22 years old when he was convicted by a jury who unanimously recommended the death sentence, according to the Indiana Capitol Chronicle. All justices concurred in the October 3rd order, except Justice Mark Massa, who did not participate in the decision.
Thanks, Maura. Moving to Daniel, give us an update in a recent ruling in the state's TikTok litigation.
The Indiana Court of Appeals reversed a lower court's dismissal of two amended complaints filed by the state against TikTok that alleged the California company had engaged in deceptive acts under Indiana's Deceptive Consumer Sales Act. In its opinion, the appellate court stated that it had little trouble concluding that Indiana's judiciary had specific personal jurisdiction over TikTok Incorporated, with the company's contacts within Indiana well beyond the minimum needed to satisfy due process. The court also noted that TikTok reported $46 million in Indiana-based income in tax year 2021. Quote, TikTok has millions of end users of its app within Indiana. Its engagement with those end users is neither passive nor fleeting. TikTok uses the internet, to which its app is connected, to knowingly and repeatedly transmit data to and from each of those millions of Indiana end users each and every hour of each and every day, the appellate court pointed out in its ruling. The appellate court affirmed the Allen Superior Court's dismissal of the state's lawsuits filed against foreign entities BitDance Limited, BitDance Incorporated, which is TikTok's Chinese parent company, and TikTok Pass-Through Entity Limited for lack of personal jurisdiction. Indiana Lawyer reached out to the Indiana Attorney General's office for comment, as well as TikTok's online press team and Indianapolis-based attorneys from Fegre, Drinker, Biddle, and Reith LLP, which are listed as counsel for the company in its Indiana case. The Attorney General's office issued a statement that read, quote, "The Indiana Court of Appeals took a common-sense approach and agreed with our office's argument that there's simply no serious question that Indiana has established specific personal jurisdiction over TikTok. By earning more than $46 million from Hoosier consumers in 2021, TikTok is doing business in the state and is therefore subject to this lawsuit. We were the first state in the nation to file suit against TikTok and look forward to continuing this fight." In its opinion, the appellate court referenced the state's amended complaints, where the state alleged that in order to induce end users in Indiana to download or access its app, TikTok misrepresented or falsely represented various information on which end users within Indiana were likely to rely when deciding whether to download or access the app.
Thanks, Daniel. A Marion County jury found Robert Reed Jr. guilty of murder following a 2-day trial for the fatal shooting of Sherry Wolf. In November 2022, Indianapolis Metropolitan Police Department officers responded to a call where they discovered Wolf lying on a sidewalk suffering from multiple gunshot wounds. A witness stated that she heard Reed and Wolf arguing and then heard Wolf call for help before hearing gunshots. The witness then called 911 and provided aid to Wolf. The witness told investigators that Reed was the shooter. IMPD Violent Crimes Unit, with assistance from Lawrence Police Department, located Reed and he was taken into custody without incident. In an interview with detectives, Reed confessed to shooting Wolf during an argument, authorities said. 2 days later, after the shooting, Wolf passed from her injuries. Reed's attorney, John F. Crawford Jr., did not immediately respond to requests for comment. A sentencing hearing is scheduled for November 8th at 9 a.m. with Judge Jennifer Harrison in Marion Superior Court 20. Now, back to Daniel, a well-known attorney and leader passed in September. What can you tell us?
Influential attorney and civic leader Robert H. McKinney died at the age of 98 on September 29th, surrounded by family at home in Walloon Lake, Michigan. His influence in Indiana law and involvement in private and public endeavors has been expansive. In 2011, McKinney, a named partner in the firm Bose, McKinney & Evans, made a $24 million donation to Indiana University School of Law, Indianapolis, which is now named Indiana University Robert H. McKinney School of Law. Admitted to the Indiana Bar in 1952, McKinney joined with 3 other Indianapolis attorneys in 1963 to form Bose, McKinney & Evans. In 1977, President Jimmy Carter, a Naval Academy classmate, nominated him as chairman of an independent federal regulatory agency, the Federal Home Loan Bank Board, along with the Federal Savings and Loan Insurance Corporation and the Federal Home Loan Mortgage Corporation. The McKinney family released a statement that read, quote, "As a husband, father, and grandfather, Bob's humility, wisdom, sense of duty, and creed of doing well by doing good comforts us in our time of loss. Above all his many other professional and public achievements, Bob always said that his family was his greatest accomplishment. In our time of loss, we are comforted in knowing that he felt this way, and that he shared the sentiment often, both publicly and privately. In the meantime, we ask for privacy as the family gathers to honor Robert H. McKinney." IU President Pamela Whitten also issued a statement about McKinney. Whitten said the Indiana University community mourned the passing of McKinney, who she called a distinguished alumnus and civic leader whose impact on Indiana and its legal landscape would be felt for generations. Quote, "Bob's extraordinary career as an attorney and a philanthropist was marked by his unwavering dedication to justice and public service. His influence on the IU Robert H. McKinney School of Law exemplified his commitment to legal education and the betterment of our community. Over his remarkable 98 years, he not only shaped the lives of countless students, but also left an indelible mark on the practice of law in Indiana. Long active in Democratic Party politics, McKinney ran unsuccessfully for the Indiana House in 1956. He chaired the state's leading fundraising dinner for John F. Kennedy during the 1960 presidential campaign and served as Indiana chairman for the presidential campaigns of Edmund Muskie, Walter F. Mondale, and Jimmy Carter. He was also outside legal counsel to Indiana Governor Roger D. Brannigan and chair of Indiana Governor Evan Bayh's Government Reorganization Committee. In 2011, McKinney set his focus on the IU Indianapolis Law School, where he began his legal studies in 1952. The university renamed the school the Robert H. McKinney School of Law in honor of his transformational gift, which included funding for 5 endowed chairs and an endowment to fund the McKinney family scholarships.
Thanks, Daniel. Now to Maura for news about J.P. Morgan.
An Indianapolis-based agricultural chemicals company is suing J.P. Morgan Chase Bank in Indiana Commercial Court after the bank allegedly issued a months-long freeze on over $3 million tied to the company. Agricultural Chemical Solutions Incorporated and the wife of the company's president are suing the bank for over $40,000 in fees incurred because they reportedly were unnecessarily denied access to the more than $3 million. A representative for J.P. Morgan Chase did not immediately respond to Indiana lawyers' request for comment. According to the lawsuit, AgChem wired $3,166,660 from its business operating account with Star Financial Bank on February 6 to the J.P. Morgan bank account of Bogumila Kopczynski, the wife of AgChem's president, John Huntsinger. The lawsuit states the money was to be used to pay off the company's line of credit with Star Financial. On February 8th, J.P. Morgan froze Kopczynski's account and issued a notice the next day stating it had restricted her accounts, the complaint alleges. Less than a week later, the plaintiff sent J.P. Morgan a written notice disputing the freezing and demanding access to the money. The notice stated that each day the funds were frozen caused damage to the plaintiffs. Star Financial's line of credit accrued interest at a rate of around $737 per day at that time. John Huntsinger told Indiana lawyer that he's frustrated with how the incident has played out and that J.P. Morgan was difficult to communicate with while his wife's account was frozen. According to the complaint, the term of AgChem's line of credit with Star Financial expired around the same time J.P. Morgan froze Kopczynski's account, and because of the freeze, Star charged an additional $6,265 in legal fees against AgChem while negotiating a forbearance agreement. On February 18th, plaintiffs filed complaints with state and federal regulators regarding J.P. Morgan's actions. Then, 10 days later, J.P. Morgan responded to plaintiffs, saying that the bank closed Kopczynski's accounts on February 21st and mailed her a cashier's check the same day, which contained the balance of her account minus the $3 million deposit. J.P. Morgan said the $3 million would remain frozen until the bank completed its internal investigation, the complaint states. Kopczynski called J.P. Morgan's wire research department the same day she received the letter. During that conversation, the department told her that Star Financial needed to authorize the return of the $3 million. After not receiving the money by March 11th, the plaintiffs called the defendants to get the money back. The money was returned on March 25th, according to the lawsuit.
Thanks, Maura. And finally, to wrap up this week's headlines, I am working on a story about candidates for Indiana Attorney General as we inch closer to Election Day. Early voting has already started, and I will be talking with Destiny Wells and Todd Rokita about the pressure they feel ahead of November 5th. You can read all about it in our October 23rd edition of the Indiana Lawyer. Okay, that'll do for this week's headlines. As always, if you want more legal news, check us out at theindianalawyer.com.